How does legal guardianship differ from a living trust? Have you ever wondered how legal guardianship differs from a living trust? These two legal tools serve important roles in elder law, but they are quite different in how they operate. Let's break it down in simple terms. Legal guardianship is a court-appointed relationship. This means that when someone is unable to make decisions for themselves, a guardian is appointed by the court. The guardian can make personal, financial, or medical decisions for the person, known as the ward. The guardian must follow court orders and prioritize the ward's best interests. This process often happens when a person is deemed incapacitated. On the other hand, a living trust is a private arrangement created by an individual, called the settlor, while they are still capable. In this setup, the settlor manages their own assets and decides how they will be handled in case of incapacity. The settlor usually acts as the trustee and can appoint a successor trustee to take over if needed. This means there is no need for court involvement in managing the trust. When it comes to control, guardianship is more restrictive. The court defines the guardian's powers and supervises their actions. The guardian often has limited input from the ward, which can feel less personal. In contrast, with a living trust, the settlor retains control over their assets and specifies how they should be managed and distributed. This gives the settlor more flexibility and autonomy. Court involvement is another key difference. Guardianship requires court proceedings to appoint the guardian, and there is ongoing court supervision. This means filing annual reports, and the court records are public, which can reduce privacy. A living trust, however, avoids court involvement during incapacity or after death. This allows for private management and distribution of assets, saving time and avoiding the costs associated with court proceedings. In terms of scope, guardianship covers personal and financial decisions but is generally less flexible. The authority of the guardian is limited to what the court grants. Living trusts, on the other hand, are highly customizable. The settlor can specify detailed terms for asset management and even care preferences, tailoring it to their individual needs. Cost is another factor to consider. Guardianship can be expensive due to court fees, legal representation, and ongoing monitoring. It typically lasts until the ward regains capacity or passes away. Living trusts usually involve upfront legal costs to create but avoid ongoing court costs. They can continue to manage assets even after the settlor's incapacity or death, providing long-term management. In practical applications, guardianship is often a last resort. It is used when no advance planning exists or when incapacity is sudden and severe. Living trusts are a proactive estate planning tool. They help maintain personal autonomy, avoid guardianship, and ensure smooth management of finances and healthcare preferences if incapacity occurs. In summary, legal guardianship involves court-appointed control over a person's affairs with oversight and less privacy. A living trust is a private arrangement created in advance to manage assets and avoid court involvement. From an elder law perspective, living trusts are generally preferred for preserving autonomy and minimizing court interaction, but guardianship is necessary in certain situations.